Out. That is number 646, 647, and 648. The application seeks to have the respondents in those three files detained for a period of 10 days to allow the applicants conclude their investigations. They also seek an order to authorize the officer in charge, DCI ICT Laboratory, to forensically examine the electronic gadgets recovered from the respondents. The applicant contends that the respondents are under investigation for various offenses, including unlawfully issuing identity cards, contrary to Section 14, subsection C of the Registration of Persons Act, that is Cap 107 Laws of Kenya, facilitating entry and exit of improperly documented persons, being an agent or carrier, contrary to Section 53, subsection 1E of the Kenya Citizenship and Immigration Act 2011, receiving a bribe, contrary to Section 6, subsection 1, as read with Section 18, subsection 1 of the Anti-Corruption and Economic Crimes Act. And finally, giving support to terrorist groups for the commission of terrorist acts, contrary to Section 5, subsection 11 of the Public Order Act, as read with Section 9 of the Prevention of Terrorism Act. The grounds upon which the said prayers are brought are to be found both on the face of the application as well as in the supporting affidavit of Corporal Lawrence Kiniti, the officer investigating or the lead investigator in these applications. The applicant contends that they are in possession of intelligence information, that the respondents are involved in suspicious activities, including irregular issuance of passports and ID cards in support of persons involved in terrorism acts. That some of the respondents are government officials employed with various government agencies, including the National Registration Bureau, the Registrar of Persons, and the Immigration Department, and by virtue of the said employment, they may interfere with the potential witnesses and impede the investigations if they are released at this point in the investigations. That some of the respondents' accomplices are still at large, and that if released from custody, the respondents may tip them off and aid their flight, and that it is therefore in the interest of public safety to have the respondents detained in custody so as to enable the police conduct and conclude their investigations. The application was strenuously opposed by a team of advocates that was led by Mr. Ndubi, Senior Counsel, and the gist of the response by Mr. Ndubi is that the instant application is an abuse of the Constitution and the rights of the respondents, as well as an abuse of the authority of the court and the court process. That Article 49(1)(h), which guarantees to an arrested person the right to be released on reasonable bail on board terms unless there are compelling reasons not to be so released, the current application seeks to ignore the provisions of the said article of the Constitution. Counsel Ndubi stated that the prosecution has failed to link the respondents with any crime, and that the sole reason for seeking their detention is that the investigators need time to contact various entities listed in the application to gather information. Mr. Ndubi referred the court to the Black's Law Dictionary definition for what amounts to a compelling reason, and according to counsel, the reasons advanced by the prosecution in the application hearing are frivolous and do not rise to the standard that is required under the law. He stated that there is no justification or reason advanced as to why the investigators cannot proceed without infringing upon the respondent's right to personal liberty. The question that this court is called upon to determine the present applications is whether there are compelling reasons that have been demonstrated by the applicants to merit the orders for detention against the respondents. By the present application, the applicant seeks to curtail the respondent's rights guaranteed under Article 29(1)(a) and B, as well as Article 49 of the Constitution, which guarantee to every person the right not to be deprived of freedom arbitrarily or without just cause, or not to be detained without trial, and to every arrested person the right to be released on bail or bond on reasonable conditions pending charge or trial, unless there are compelling reasons not to be so released. It is manifestly clear that the rights in question are not absolute, and that they may be limited where just cause or compelling reasons have been demonstrated to warrant their limitation. In the present case, the applicant will have the respondent's right to liberty curtailed by their detention in custody pending completion of investigations into crimes of which they are suspected. The basis of the said prayers, as stated above, is that the applicants are in possession of intelligence information pointing to the respondent's involvement in suspicious activities, including irregular issuance of passports and national identification cards in support of persons involved in terrorism acts, and that by virtue of the said, by virtue thereof, some of the respondents, by virtue of being engaged as government employees within the National Registration Bureau and the Immigration Department, there is a likelihood of interference with the investigations and potential witnesses if they are released. The question of pre-charge detention is not a novel one. It has been the subject of frequent litigation, and numerous decisions have been rendered by the superior courts in respect of the said question, and this court can therefore do no better than to be guided by the wisdom of the higher courts. The High Court in the case of Michael Rotich versus Republic, 2016 EKLR, Justice Kimaru, as he then was, considered the provision of the 24-hour rule and held that an arrested person, upon being arraigned in court, should not be detained without a charge or a holding charge being preferred against him. The judge stated, and I quote, "In compliance with Article 49(1)(f) and I of the Constitution, the applicant was brought before the 24 hours of his arrest. However, contrary to Article 49(g) of the Constitution, the applicant was neither charged nor informed of the reasons for his continued detention. As stated earlier in this ruling, the recent trend where a person is arrested and arraigned in court within 24 hours, specifically for the prosecution to seek extension of time to continue to detain such a person without any charge or holding charge being preferred against such a person, is unconstitutional. The police have no authority in law to arrest and detain any person without sufficient grounds. Those grounds can only be sufficient if the police have prima facie evidence which can enable such person to be charged with a disclosed offense. The fact that the prosecution has a prima facie evidence of a disclosed offense can be presented in court from a holding charge setting out the particulars of the offense. Such a holding charge will enable the accused person to know of the reason of his arrest as provided for under Article 49(1)(a) of the Constitution. It will not do for the prosecution to present a person who has been arrested in court and to seek his continued detention without a charge or holding charge being lodged in court. It is unlawful for the police to seek to have any person who has been arrested to continue to remain in its custody without formal charge being laid in court. If this trend continues, it will erode all the gains made in the advancement of human rights and fundamental freedoms as provided in the Bill of Rights since the Constitution was promulgated in August 2010. A person's right to liberty should be respected by all." End of quote. The decision in Michael Rotich has been the subject of comment by later decisions of the High Court, where courts have deviated from the holding of Justice Kimaru, to this regard I refer to the decision of Betty Jemutai Kimeywa versus Republic 2018 EKLR by Justice Mureithi. When faced with the same issue, the judge had the following to say: "With respect, while I agree with the need to respect the right to liberty of suspects, I am unable to agree that the police can only produce a suspect before court when the investigations into the offense are completed and or when they present a holding charge awaiting a full charge when investigations are complete. A holding charge, which need not be accurate in its particulars, as the investigations will be ongoing, may indeed offend the very foundational principle of certainty of a charge, which requires that a charge gives reasonable information on the offense charged under Section 134 of the Criminal Procedure Code, so that upon being brought before the court, an arrested person may be charged, or he may be informed of the reasons for detention being continued, say, to facilitate completion of investigations or his presentation for assessment of fitness to plead before a plea is taken, or he may be released if the court, for example, found no reasonable grounds for his continued detention, or he may be released on bond pending formal charge or trial. The Constitution does not say that the police may only arrest a person when there is prima facie evidence of an offense. It must, of course, require a probable cause for an arrest, but not a prima facie case in its technical acceptation of evidence upon which a court may convict, if no evidence is given on behalf of the accused person. For this holding, the court made reference to the case of Raman Lal Trambak Lal Bat, that is versus Republic, 1957, East Africa Law Reports at page 322, where it was held that a prima facie case is one on which a reasonable tribunal, properly directing its mind to the law and to the evidence, could convict if no explanation is offered by the defense. A police officer cannot be required to make a sort of judicial determination of existence of a prima facie case. That is the province of the trial court at the stage of consideration whether a case to answer is established against an accused person. A reasonable suspicion of commission of an offense based on available evidence will suffice to give probable cause for an arrest. Again, that is the end of the quote in the second decisions that I've referred to. Again, I will refer to the case of Sudi Oscar Kipchumba versus Republic through the National Cohesion and Integration Commission, that is 2020 EKLR, where Justice Ngugi, as he then was, had the following to say on the question of pre-charge detention. And I quote, "The court in the Michael Rotich case, while decrying the ubiquitous use of pre-charge detention, ruled that the constitutional meaning of to be informed of the reason of detention continuing can only be met with the presentation of a holding charge at the very minimum. There are good reasons for this purposeful reading of the Constitution. Why should the police arrest a citizen if they do not even have a provisional view of the offense that the citizen has committed? It will seem repugnant to the ethos of the Constitution, of the constitutional justification of the exercise of power and authority in which our Constitution is steeped in, to encourage such practice, even if not categorically unconstitutional textually. In many cases, such police action would be, in context and effect, unconstitutional. This would be the case where the police conduct reveals a pattern or desire to overreach or to deploy the criminal justice system in a manner which unnecessarily diminishes rather than aggrandizes personal liberty or autonomy of the arrested individual. So, even while accepting that the text of Article 49(1)(f) may in certain circumstances and contexts comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application to have him so held, the state must satisfy a double test. And this is the test that the court went out to lay. First, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial. That is, the rights of the arrested individual, the public interest, order and security, the needs to preserve the integrity of the administration of justice, and the interest of the victims where appropriate. By virtue of Articles 21 of Article 1 and 259 of the Constitution, the court must act to aggrandize, not to diminish personal liberties of arrested individuals in line with the three interests. Differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests without rareifying or essentializing any. End of quote. In the case of Joseph Thiongo and 17 others versus Republic, that is 2017 EKR, Justice Ngugi once again reiterated the need to safeguard the rights of the individual in light of the criminal justice system and the need to secure peace and security for the rest of society. He stated, the defense would be correct to argue that such a blunt response to the breakdown in law and order would be tantamount to sacrificing the right of the accused person in order to secure peace and security for the rest of society. Needless to say, our Constitution no longer countenances such an approach. Such was the approach to law and order that justify the authoring into our law books the infamous Public Order and Security Act. The logic that it is necessary to simply detain some dangerous citizens in order to maintain law and order for the rest of society. That logic has been substituted in our Constitution with the opposite logic, that every person is presumed innocent and entitled to bail and not to remain in remand unless compelling reasons are shown. The authority of the court to deny bail where compelling reasons are shown can now not be invoked as a reason for the scrutiny for the security apparatus and the state to refuse to undertake their foremost duty to protect all citizens and maintain law and order in the society. Where the alleged sources of threat are known and the potential victims of the illicit activities are known as here, it would be to reduce the state's monopoly of violence and duty to protect its citizens to a sacrilegious impotence to conclude that only the remanding of a particular accused person who are not themselves the alleged sources of the threats is the method to protect potential victims. End of quote. Being guided by the authorities which I have cited above, it is established that Article 49(1)(h) in certain circumstances and contexts does comprehend a scenario whereby an accused person's liberty may be limited if compelling reasons are shown to exist. Before a court can issue such an order, however, it must be persuaded that the state is acting in absolute good faith, and the state must also demonstrate that the continued detention of the individual without a charge is the least restrictive action it can take while balancing the quadruple interests that are present in a criminal trial. Once again, the interests are the rights of the arrested individual, the public interest, order and security, the need to preserve the integrity of the administration of justice, and the interests of the victims of the crime where appropriate. Applying these principles to the present application, the court must consider whether the allegations in the supporting affidavit, sworn hearing, meet the criterion that has been set above and demonstrate the existence of a compelling reason and justify the continued detention of the respondents. Having done so, and having considered the affidavit of Sergeant Lawrence Kiniti at depth, the said affidavit was sworn on the 8th of December 2025, I find that the main ground advanced by the applicant in seeking to curtail the respondent's liberty is the need to prevent potential witness interference and the interference with investigations in general. Although the apprehension for interference with investigation may amount to a compelling reason, it is not a justification for extended detention of suspects for an unreasonable or unjustifiably long periods. It is incumbent upon the investigative agency to move with all necessary speed to ensure that any witness testimony or other evidence which is considered delicate and which is subject to interference is promptly gathered and safeguarded at the earliest opportunity. In the present scenario, it is not in question that the respondents were arrested on the 5th of December 2025 and to date, that is the 11th of December 2025, they have been in custody of the police for a total of 7 days. It is expected that during the intervening period, the investigators have taken all necessary steps to safeguard the evidence of the witnesses whom they consider to be susceptible to interference. Having so found, the upshot is that although the applicants have demonstrated compelling reasons to detain the respondents in custody so as to safeguard the integrity of the investigations, it is the opinion of this court that the period which the respondents have been in custody, that is from the 5th of December to date, is sufficient time for the investigators to take necessary steps in order to safeguard the investigations. And as such, the court finds no justification for any further detention of the respondents. Consequently, the respondents may be set at liberty forthwith unless they are lawfully held in custody. This is the order of the court. Most